Welcome to the legislative update for the week ending Friday, June 4th. My name is Colleen Patterson, and I'm the Director of Employer Services and Compliance at Savoy. There really wasn't a lot of legislative activity this week. However, there are a few items in the news that I thought are still important to note. First, the Small Business Association announced on June 1st the closure of the Paycheck Protection Program. Since the PPP was first introduced through the Coronavirus Aid, Relief, and Economic Security Act, which we all know is the CARES Act, it dispersed more than $798 billion in loans to small businesses and nonprofit organizations. That means over 8.5 million employers received PPP loans to cover payroll costs. As we know, that included items such as benefit expenses, as well as non-payroll costs such as rent, mortgage interest, utilities, and so on. After some initial backlash that the smallest businesses were having difficulties obtaining a PPP loan, the SBA noted that in 2021, 96% of the PPP loans went to businesses with fewer than 20 employees, and the average loan was $42,000. So moving along, there's been some activity on the Hill this week. There were several pieces of proposed legislation that were recently introduced to Congress that could significantly alter the American payroll landscape. Bills and committees in the Senate aim to create payroll tax credits for the hiring of military reservists and for coronavirus-related training, as well as to provide tax relief to workers who are performing work duties remotely. So the one bill that is of most interest to keep an eye on is House Bill 1807 or 1807. It's also known as the Businesses Preparing for a Better Tomorrow Act, and it was introduced on March 11th and is currently under review in the House Committee on Ways and Means. This bill proposes a payroll tax credit to businesses who perform training associated with protecting employees from the coronavirus itself, so COVID-19. The credit applied against employment taxes for each quarter would amount to 50% of the qualified workplace training expenses incurred by the employer per quarter. The credit is proportional to the number of employees, with limits based on employer size. And this credit would only apply to expenses incurred between March 12th, 2020 and January 1st, 2022. So stay tuned, as this is getting a lot of momentum. So moving along, as a result of the COBRA subsidies under ARPA, we've received countless emails regarding how and when do employers bring back furloughed employees and what happens to the COBRA subsidy and so on. So here's what brokers and employers need to know. There are payroll considerations for rehiring employees after a layoff. We're all well aware that the coronavirus pandemic forced many employers to place workers on temporary furlough, or in many cases, even to terminate their employment agreements entirely. As the economic damage of the pandemic recedes and local and state executive orders are lifted, many employers are faced with hiring or rehiring to meet the productivity needs of their businesses. Therefore, several states have passed regulations regarding rehiring. Most significant is something called the right to recall. Several states and localities have enacted right to recall ordinances aimed at ensuring that terminated or furloughed employees are the first to be considered for rehire when an employer makes a position similar to the one formerly occupied by the terminated employee. Several cities are beginning to take this action. In our footprint, specifically, New York, Philadelphia, and Baltimore have adopted regulations creating the right to recall for furloughed or terminated employees. Other areas include the state of California, as well as many localities within California. Also, Washington, D.C., Honolulu, Minneapolis, and New Haven. And we're seeing this as a growing trend, so it's definitely something to be aware of. Other factors to consider when rehiring furloughed employees or hiring new workers for an expanded business include industry contract requirements. So think of something like prevailing wage, collective bargaining agreements, new hire reporting rules, and benefits and paid leave considerations. So The other thing we also want to make sure is that if this is for employers that are ALEs, there are some specific rules around rehiring those employees too, and how do you recount them and so on. So definitely make sure that you're paying attention to that. Next, another item that I wanted to make everyone aware of is the advanced explanation of benefits under the No Surprises Act. As part of the CAA, the No Surprises Act is meant to protect plan participants from unexpected charges after receiving care. An important piece of compliance with this law is the advanced explanation of benefits. So what is the advanced explanation of benefits? It provides participants with information related to the expected cost associated with receiving care, with a focus on out-of-network providers and associated charges. The document's going to contain information about billing and diagnostic codes, network status, a good faith estimate, and much more. Participants can request the advanced EOB, and the document must be provided within 1 business day or 3 business days if that request is made at least 10 days or 10 business days before the scheduled procedure. The new rule applies for plan years starting on or after January 1st, 2022, which is just around the corner. Plan sponsors will be relying on insurers and TPAs to meet the new responsibility. However, this is the reason why I wanted to bring this to everyone's attention, and that is because employers must amend their SPDs to include this new information, including a description of the right to request advanced EOBs and the steps needed in order to do so. Employers should also consider asking their vendor or TPA how do they plan to meet these requirements. Employers should review their current agreements and contracts as necessary to include responsibility for providing advanced EOBs, and also responsibility for any penalties and/or costs that may be associated with missing deadlines or providing egregiously incorrect information. Next, the other thing I wanted to touch on here is just a quick mention about the new broker transparency rules. We're starting to hear a lot more talk and rumblings that information is going to be released in the next few weeks, specifically about the new broker transparency rules that are going to be going into effect this upcoming December, by the end of December. So definitely stay tuned. And as we learn more, we will for sure put more information out about that. Lastly, I wanted to touch on and let everybody know that the draft 1094, 1095, B, and C forms for the upcoming ACA reporting season have been released by the IRS. There were no significant changes to note to the forms. However, it is important to note that draft instructions have not been released yet, so they're certainly to follow soon. So this concludes our update for this week. As always, should you have any questions, please reach out to your dedicated Savoy team and continue to use the resources that are available on our website at savoyassociates.com. From all of us at Savoy, stay healthy and safe. Thank you for joining us today.